Devidas apresentações, meu nome é Pedro e eu presido a Comissão de Direitos Autorais, Direitos Imateriais e Entretenimento da OAB. Tenho aqui do meu lado Felipe Dannemann, que é o presidente da Comissão de Propriedade Industrial da nossa mesma OAB. Tenho aqui do meu lado esquerdo Graziela Bonfim, que preside a Comissão de Inteligência Artificial da OAB, e temos nosso diretor de Inclusão Digital, Rocha, também da nossa casa. Nós temos um dia especial, temos um convidado estrangeiro, e o nosso convidado estrangeiro está aqui pela gentileza da PUC do Rio de Janeiro, que é a instituição onde eu leciono nos últimos 17 anos, que importou o nosso gentil convidado, e o professor Ryan, também muito gentil, topou os desafios de ir comigo palestrar na Universidade de São Paulo, onde eu estou lecionando nesse semestre, e também lecionou na PUC do Rio de Janeiro, e hoje ele está aqui na OAB do Rio de Janeiro, na sua despedida. Daqui a pouquinho ele vai pegar o aeroporto Tom Jobim e voltar para a terra dele. A propriedade intelectual é uma das áreas mais interdisciplinares do direito, e ela lida com arte, ela lida com criações ornamentais, ela lida com criações utilitárias, ela lida com criações distintivas, ela lida com novas tecnologias, e claro, ela lida com direito digital e lida com inteligência artificial. E não tínhamos um convidado melhor para ouvir, para refletir, para aprender, que vem de uma cultura distinta da nossa, porque ele é um advogado, ele advoga no Reino Unido, ele advoga nos Estados Unidos, o que significa dizer que ele passou nas provas da OAB, das suas respectivas circunscrições. E além de ser um advogado no Reino Unido e nos Estados Unidos, ele tem como consultor atuado em jurisdição como África do Sul, como Austrália, na Ásia, advogando o caso que seria o caso tese da vida dele, que é a ideia de uma autoria transcendental, que é uma ideia de uma titularidade que não é afincada no antropocentrismo, e por isso ele está aqui hoje para nos contar de uma experiência. E eu tive o cuidado de ler o livro que ele escreveu, O Robô Razoável, The Reasonable Robot, e eu achei um livro extremamente interessante. Como nós somos da vida acadêmica, o fato de a gente gostar de um livro não quer dizer que concordemos com as teses dos livros. E exatamente porque temos um coração plural, eu tive o cuidado de mandar um e-mail longo para o Ryan, dizendo: olha, Ryan, eu não vou no nosso evento dizer as 300 razões pelas quais eu discordo de você, mas posso dizer a você que eu aprendi contigo. E que pensar diferente e ouvir o outro com carinho, sem violência, faz parte daquilo que a gente quer na advocacia e também na academia. Então temos hoje um encontro de dois Ryans. O Ryan professor, o Ryan advogado, como só acontecer para muitos daqui que estão presentes. Que damos aulas, que recebemos aulas, que estamos na labuta da advocacia. Uma pequena explicação. A OAB sempre dá toda a liberdade para que a gente organize os eventos, sempre que a gente puder fazer gastando a menor quantidade de dinheiro possível. E, portanto, não teremos uma tradução a vocês. Eu sei que isso pode parecer um pouco excludente, mas esse evento, salvo engano, está sendo transmitido para a OAB pela YouTube, depois o evento vai ficar gravado e tem lá as legendas que são feitas por inteligência artificial e tem lá seus defeitos. Mas ainda assim me parece que entre uma ótica que pode parecer excludente, ou seja, um evento que não é na língua portuguesa, na língua brasileira também, do artigo 13 da Constituição da República Federativa do Brasil, que é um bem público de uso imaterial, e não ouvirmos talvez o grande especialista do Ocidente nessa interface entre IA e PI, eu acho que a gente tem mais a ganhar do que a perder. Então eu peço desculpas pela ausência de tradução, mea maxima culpa, mas também é o que eu pude fazer com o orçamento que eu tive. Dito isto, Ryan, it's a real pleasure to have you here with us. And I'm very happy that PUC has brought you to Brazil and you once more, and you have the knowledge of the Carioca culture. And as a token of my gratitude for you, I would like to give you something that's important for me and that represents the absence of racism, the adventure of pluralism, history, the beauty of the encounter of peoples of different nationalities towards one unique goal. And for my colleagues here in the table, since sometimes dealing with me is not very sweet, I brought some caramels for you. So, with the representation of the absence of racism in our history, because Vasco was one of the leaders against racism and towards an inclusion throughout foreigners and nationals in one unique and included culture, I would like to start asking for sorry for the crowd before our momentary absence of our president. Perhaps she will reach in some while from now, but we should start and we should continue. So that's life. The show must go on. So Ryan, please, you have 1 hour for your speech. Then we would collect questions and comments from Graziela Bonfim, our president, from our president Felipe, and from our director William. And then afterwards, the whole crowd can ask questions. You can ask in Portuguese if you want. I will note them down and I will translate for Ryan, and then he will pick all the questions up and we will summarize and conclude perhaps around 12. Okay? Thank you very much for everyone, every soul that's here with us today. Ryan, please.
Oh, thank you. It's a great honor to be here. The clicker is not working though on the PowerPoint, and while someone attempts the clicker, we don't need the slides. But you know, it has been a great opportunity to have an education in Brazilian culture, and it's exciting to know that everyone here supports Vasco. And I understand there are some other teams in Rio, but they cheat and they're mean to children. So you know, I'm going to bring this message back to America and to England. So I've been interested in artificial intelligence for a while, which I think has been interesting for a long time, but it has only really gotten interesting in a way that sort of normal people who don't practice in the AI area have become aware of. This is a picture right now, which you can see maybe somewhere, of a prompt that I put into Google Gemini, and I said, generate a creative image. It said, sure, here you go, and I got an image of a cat cooking a souffle. I think this says a lot of very interesting things. I think it has kind of interesting social, economic, and technical implications that an AI can do this. I think also for those of us who are interested in the law, it has really profound, interesting questions for copyright. You know, what it means to make an intellectual creation or for something to have the spirit of an author, you know, and what this means for us as people increasingly use AI that gets better and better and can do more and more, and how we are going to kind of legally structure our relationships in a world where we're using AI. Because people have been using AI to make art for a very long time, since at least the 1960s. You know, complicated questions of what the AI was doing and what the person was doing and how they built the systems, you know, but in 2022, when you had the public release of large language models like ChatGPT, suddenly these systems went from something that computer scientists were using in academic sorts of ways to something that now everyone can use. And now 100% of my students use ChatGPT, including to do their exams. But I am using ChatGPT now to grade their exams. So, you know, I tell them this is getting themselves out of a job, but you know they're too busy with ChatGPT. So, you know, we'll unpack some of this in a bit. But people have very strong opinions about AI for lots of reasons. This is a picture from the writer's strike in Los Angeles, where I spend much of my time. It was from 2 years ago. And, you know, how many of you are lawyers or aspiring lawyers? If you could raise your hands. All right, so we're all lawyers here. So, you know, for those of you who haven't been in AI for the past 40 years, some people have said, you know, 10 years from now, lawyers won't have jobs, robots will have all of your jobs. And so here we are in 2025, and the robots have not yet taken your jobs. You know, maybe the next 10 years will be different. You know, people have said this to creatives too, like, you know, there's not much you can do that an AI can't do. Not right now, but 10 years from now. 10 years from now, AI will do everything you can do. And then, you know, 10 years would happen and not much would happen. But when the writers went on strike, they didn't say, we're concerned about AI in 10 years. They said, a major reason why we are striking is the use of AI in the creative industry. And it was not so much that they said AI is taking our jobs right now, but they did not like what studios were doing with AI. Studios would have an AI write a script, and the human writer would fix the script, but by doing that they could pay less money. Or actors were showing up to auditions, they had lots of pictures taken, they read long scripts, and then they would apparently show up as extras in films without being aware of it. So these were almost more objections to labor practices, but it was taking AI in the creative industry from something that is kind of theoretically, academically interesting to something that has a real social and economic impact right now. And so this has not escaped the attention of anyone, really. AI is on the front page of the news along with whatever interesting thing American politicians are doing at the moment. But everyone appreciates they have very different feelings about AI, but they know it's going to be very disruptive. Maybe they don't know exactly how, but it's going to do something. And so there is a perception we have an AI arms race right now between the US and China and Europe. This is a technical one. This is a financial one. Massive sums of money are going into AI development right now. Private investment in AI in the U.S. right now is $100 billion a year, compared to $5 million in England and, $10 billion in China. Along with this, governments are setting AI industrial strategies. And part of that is the legal framework that you have for AI. So you have the United States, which right now is saying, we'll just leave it to the market and everything will work out. We have Europe saying, of course, we're going to leave it to regulators. Without a hint of irony, a European regulator said during the passage of the EU AI Act, the U.S. is leading in AI development, but we are leading in regulations. So I did some of the work that led into the EU AI Act. I was recently writing a commentary for it and trying to figure out how it got here because it didn't make a lot of sense to me, some provisions, like you have to be transparent, but not what that means or how it's enforced or what the remedies are for not being transparent. But Europe is sure that they're going to regulate and then technology will follow the regulation. So you have two very different visions of how to regulate. I want to focus a bit today, although we'll talk about AI in different areas in AI and intellectual property law. And this is something that regulators have also gotten specifically interested in. And to show you how quickly thinking has evolved, there have been many kind of consultations or work on this over decades, but in recent times, the U.S. Patent and Trademark Office in 2019 announced a request for comments where they asked the public, what should we be thinking about with AI and IP? And in 2020, they published a report that said, not much. We've kind of got it. There's new technologies. IP will adapt. In 2023, they launched another. So just 4 years later, in 2024, they published a very detailed guidance saying, using AI and R&D can make it, difficult or impossible to get patents. You have to have traditional human inventors. If you have joint inventorship, this may be a problem. These are the tests for it. Here are very detailed examples of chemical and mechanical engineering of what an AI can do and what an AI can't do. This is going to have challenges for prior art determinations. So, in 4 to 5 years, it's gone from there's not much to do here to actually this is going to be very disruptive to our existing systems. And there's all sorts of disruptive things people are doing with AI. This is a picture from a company called Clearview. It trained an AI for law enforcement to recognize people from pictures on the internet. So if a police officer is interacting with you or a border authority, it will tell them who you are, maybe show them your Instagram feed or your Hinge profile. Some people think this is very good for security. Some people think it is dystopian and privacy violating, but it has important copyright questions about whether you can use people's pictures from the internet. And to train modern systems, many of them, they require huge amounts of data, and the easiest and best place with huge amounts of data is the internet. And so, of course, much of the content on the internet is copyright protected, and this raises interesting questions about what you can do with that we'll come back to. And, people are using protected content for all sorts of things, like putting Jerry Seinfeld in Pulp Fiction, for fun and parody and pastiche. They are using it to make synthetic content of all sorts. This is a picture of President Trump rescuing hurricane victims personally. Of course, it is not a real photograph, but while people have been able to make synthetic content or deepfake content for a long time, it used to require a lot of time and resources and technical sophistication, and I can make this sort of thing now with ChatGPT in 5 minutes on my phone and post it on Instagram, and so these things can have very disruptive kind of impacts on social discourse and political disinformation. And of course, people are using it commercially, so actors are appearing for product endorsements they have not done. Bruce Willis often in Russia, apparently, where he's very popular. He's going to have some enforcement problems with this, but it raises interesting questions about how much you can control your image and your name and your likeness and what other people do with it, with or without your consent, or in certain sensitive areas like intimate sorts of videos. And these uses, extend to challenges in all sorts of areas, including, rights to free speech and expression, and most large language models, which are things like ChatGPT, operate by statistically estimating what word should come after what word. So this teaches us that language is actually very formulaic because it makes very convincing sounding sentences. But it is not necessarily very good at checking the accuracy of those sentences. They're working on it, but not well. So if you ask ChatGPT what I've been accused of doing, it may say, murdering Vasco supporters, and that's not true, but, it doesn't validate necessarily what it's saying. Speaking of football, I want to touch on, copyright for a bit, and, these issues of training and whether you can train something on copyright protected content. So these are two images. The more normal appearing image is from a football match, and a photograph that is controlled by Getty Images. Getty Images is a big US-based right holder. So if you want to use this image in your book or for a sales campaign, you pay them money and you license it. They will also license it to you for training an AI system. Generally training machine learning based, deep learning based and large language and foundation models involves lots of copying of the data. You expose a machine to this data. It helps adjust the data connections in a model, and then the machine gets better at doing certain sorts of things like generating image in generative AI systems, or recognizing patterns or images, or classifying things. The image on the right was made, or my right, was made by an AI system called Stable Diffusion, which is a generative AI system. And it's owned or controlled by Stability AI, which is based in the UK. And you can tell just by looking at it that it looks like the image on the right had some input from the image on the left. And you can tell both because the images look pretty familiar, but also critically, the left image has a Getty Images watermark on it, right? So it says this is our image, and to take that watermark off, you need to pay us. But the image on the right has the watermark recognizable, although it's pretty distorted. So Getty Images and many right holders do not like their AI system, their content being used this way. Although right holders, have a variety of different interests in this. Some of them have moral objections to their work being used. Some of them don't like that generative AI systems can emulate the style of a human artist if they've generally been trained on that artist's style. So you could say, generate a new song in the style of Taylor Swift, generate a new painting in the style of Picasso. Historically, style is not something that we have protected per se in the US and the United Kingdom with copyright. And we don't do that because we think, copyright should not have too broad of a reach, and we do not want it preventing other artists from copying style. But also, historically, it is very difficult to copy style well. Right? So I could spend the rest of my life training to sing in the style of Taylor Swift, and it would not be very successful, or to paint in a Picasso-like style. Although I did recently see a museum in Sao Paulo. What was the name of it?
Alfredo Volpi. The museum must be.
Yeah, must be. There were some pieces I felt like I maybe could have done myself there, but others never. But anyway, with the generative AI system, you could ask it to emulate style, and it could do so. Some artists don't like that. Some artists don't like it on philosophical grounds, and some don't like it on economic grounds because, maybe it's a lot cheaper to have, Stable Diffusion make a Taylor Swift song than to have Taylor Swift make a Taylor Swift song. Well, it is cheaper. Until recently, the songs were still pretty bad. It sounded a little like Taylor Swift maybe, and you would listen to it and it was interesting that an AI could make a song that kind of sounds like Taylor Swift made it, but they're getting very good very quickly, much better very quickly, and they still don't sound quite like Taylor Swift, but they're more and more passable. It may be in 5 or 10 years, it sounds a lot like Taylor Swift. It may sound better than Taylor Swift in 5 or 10 years, although, again, something people have different opinions about. Getty Images probably cares less about that. Getty Images cares about money, and Getty Images definitely does not like the idea that, not that people won't use the work, but they won't be paid for their work. So there's, powerful economic interests at stake. The AI developers also have powerful economic interests. So they say, well, if we can't do this, you can't have modern AI systems. And so if you prohibit us from doing this, well, either you will not get these AI systems, or we will just all move out of your jurisdiction. We will all move to China where we can do this, or Japan. And also, different jurisdictions have different laws on this, right? So Japan, for example, very early, I think 2018, passed a law that broadly provided that you could do this sort of thing for machine learning and text and data mining exceptions with copyright protected content. Other jurisdictions are clear that you can't do this sort of thing. The United Kingdom, for example, you probably can't. In the United States, you have a fair use doctrine, which basically says something could be infringement, but it's not if it meets this factor test. When you're doing something we think of as fair, so this is, for example, maybe me using this slide in a talk and explaining about it, that lets me use it. If you don't use too much of a work, if it doesn't impact an artist's market too much, and kind of the most important element of this is whether a work's use is transformative from its prior use. So the AI companies say, look, we're not using your image so much, we're using 1 billion images, and no human being is even looking at this. We just have machines crunching huge amounts of data. And at the end of this, what comes out is a trained model and different model weights. Nothing could be more transformative than turning an image into a bunch of model weights. And so, this should be fair. And also they say, and human beings train on images in the same way all the time, right? You look at an image, you don't pay to train on it, so this sort of thing shouldn't be infringement. So this is really a critically important issue right now in AI and IP. In the United States, the damages for copyright infringement can be very high. Per instance of willful infringement, which means kind of you knew what you were doing was wrong, but you did it anyway, the damages can be $250,000. So if you multiply that by 1 billion, you get a very high number, a number that probably no one else could pay for. And there are some cases kind of about things like this, but no case really on this yet. There was a very famous case called Google Books, the Authors Guild, and this involved Google's efforts to digitize every piece of literature in the world and, do all these great things with it, put it online, let people search it, kind of make everything accessible to everyone. Right holders did not like that either. Wanted a license or wanted opt-out provisions or didn't want their works used. And at the end of the day, the court found that what Google was doing, and there were some safeguards, they were not just allowing the works to be made available on the internet, only small portions of them were for searching, or they had opt-out provisions. The courts held that this was fair use. So, that case has similarities to this, but there's really no case kind of directly on it. There is, though, a lot of litigation going on about it. It's not only infringement in the training. It is also sometimes about access. So there's a bunch of cases going on against Meta right now in California. I think those ones are in California, claiming that Meta took works from pirated websites where they were illegally collected in the first place, and that was the easiest way for them to get training data, and they did it even though they shouldn't have accessed it in that way. There are claims of trademark infringement. So, for example, you saw the watermark being distorted, so they claim that's use of their trademark, and it's blurring, and it is tarnishment of their trademark. There's claims of unfair competition and unjust enrichment. There's claims of copyright infringement in the output, right? So you can go back and look at this and ask whether just standing by itself these works are infringing. There has been access to the original work, and different jurisdictions have different rules on what's infringing, whether there's substantial similarity here. But all these cases mainly involve whether the training was acceptable, and so it is not only in the United States, it is in many different jurisdictions, but the United States is very important because many of the AI companies that are leading development are based there, and also there is a very aggressive, IP system for damages should they be found to be liable. Right? There's about 40 of these cases right now in the United States, many of them focused in California and New York. Some of them are going up to appellate courts right now for interlocutory appeals, so this is kind of sending up legal questions to an appellate court in advance of trials. But none of them have gotten to the end of the road on kind of the key merits of this underlying question, whether this sort of activity is allowed. I think that the Supreme Court will ultimately weigh in on this in the U.S., but that takes a very long time. And in the meantime, developers and enterprise users and creative industries kind of have a lot of uncertainty about whether or not they can do this sort of thing. But everyone is just kind of doing it, except for some of the big enterprise clients. Or some of the big enterprise clients have indemnification agreements, like Google says if you use their enterprise software, if you get sued for infringement, we will cover all of your costs in your defense, and if you are liable, we will pay for it, right? So, very complicated contractual deals being done with people in this space for users and enterprise clients and so forth. At the same time, there is very aggressive lobbying because, either the courts will say, well, this is what the law says, or parliaments or Congress will change the law. So in the United Kingdom, for example, the Tory government, the Conservative government, was trying to pass, where this sort of activity is probably not allowed under UK copyright law, was trying to pass a very broad exception. It was strongly opposed by right holders and defeated, and in the UK, you have a lot of right holders and not so many AI companies. The Labour government, which is the Liberal government, has also come out supporting a very broad exception. So we will see what happens, but this is very actively before them. And in front of the federal government in the U.S., there are a lot of proposals and analysis for exceptions like this, and also for all sorts of AI regulations, although at the moment not so much going on at the federal level, except that the current administration wants to do the opposite of whatever the last administration did. And so here we get it here. And most of these cases have been brought against a few companies. I did not make this chart of the last two. It was done by a professor, Ed Lee, in Chicago. But most of the cases are against Microsoft and Meta and OpenAI and Google, but also some of the smaller players like Stability AI and Suno. So, very interesting and exciting times for those of us working in copyright infringement. It is interesting kind of the parallels between having a person train on content versus having an AI train on content, and whether and how we should think about these things differently. Pedro mentioned a book that I had written. It's getting a little dated, but it feels pretty recent for me, or at least I'm not ready to write the next book yet. But this book looks at kind of the different areas of the law in which people do something and AI does something, but the law often treats that differently, and maybe that's not so good. So for example, I am often interested when I come to Brazil and I see elevator attendants. I see fewer of them than I used to, but we still did see some elevator attendants. You very rarely have these in the U.S. now, in part because the job could be automated by an elevator panel. But you have lots of reasons why you might want to automate or not automate, but one that people often don't think about is taxes. So in the US and the UK, if you hire someone, you have to pay the government for their social benefits. So you pay extra, whatever you pay them, you pay the government extra. If you get a machine to do a job, you don't have to pay the government extra in your labor taxes. There's actually a lot of ways that you pay more in taxes to have someone do a job than to have an AI do a job. And so maybe this is not the right system, that we have two different tax treatments for AI doing something. Speaking of having AI do something a person can do, I have a self-driving car. It's a Tesla. This was before the recent Tesla stuff. I do like the car, but the AI is not so great. Sometimes it just brakes for no reason. I'm on the freeway and it will just stop, and this is dangerous. But it is very convenient. In principle, at least, you push a button, it goes from my house to my work. I was in Arizona 2 months ago. They had self-driving Ubers, no human driver anyway. The car just does the whole thing. Maybe secretly there's a remote someone, maybe. It's a little confusing, but anyway, you kind of have self-driving cars now. But if that Uber runs someone over, you have a strict liability framework for products. If I run someone over, you have a negligence-based liability for injuries. So again, you have two very different legal rules that come into apply, again with some odd outcomes. My book looks at this and says, actually, we kind of end up better off when the law does not distinguish between AI and human behavior as a basis for rules. So I'll talk about this a bit, in the AI context with outputs, and you can tell me if you think it makes sense. And in all sorts of areas, though, this really applies. We have, for example, AI increasingly involved in the practice of law in the United States, and lawyers and judges have very strong opinions about this. Some lawyers just do not understand how AI works. For an older generation, they struggled with email. For my generation, they struggle with AI, and they think that if they ask ChatGPT to write a brief, they can just give the brief to the court, and they don't bother to read the brief or check the brief. And it is amazing how often this continues to happen. Lawyers get sanctioned. Courts do not like it because these briefs will look very persuasive sometimes, very well written. But, there will be a case, and they don't check the case, and there is no case, and the whole thing is just made up. And so lawyers will say, well, do we need special rules about this? Do we need to keep people from using generative AI? For me, again, we already have rules on this. When you sign your name at the bottom, right, of a brief, you say, this brief is my brief, whether you have your intern write it or ChatGPT or another partner. You don't sign your name on it if you haven't read the brief and made sure that it says what it says. So you don't really need a separate rule for this. It will also be increasingly challenging. You're not going to be able to not use generative AI, right? It's already being worked into Google, so you Google something, now it's generative AI. It's being worked into Westlaw and Lexis and legal search terms. My Microsoft Word uses Copilot, so people used to joke when I talk about AI authorship, like, oh, Microsoft Office isn't my co-author, and well, now I can just say, write an article about this, and it will just write an article about it, right? So these tools will become inevitable for use, and judges are going to use them, or their clerks are going to use them. And just as lawyers don't read their briefs, no one here, but some judge somewhere is not going to read what their clerk put together with ChatGPT. I remember I spoke to a group of American judges a couple of years ago, and I asked if any of them had ever used ChatGPT, and none of them raised their hands. And I said, and have your clerks used ChatGPT? And they all suddenly realized that maybe they needed to look into this a bit, and that it was going to be a challenge. But we can talk a bit more about AI in the practice of law later. What I want to talk about is AI making stuff, because I personally think it's very interesting. And this is an image that I also had Gemini make, though I gave it a little more direction than generate a creative image. But, the UK was the first country in 1988 to make a law about this. And the law says if you have a computer make a creative work without a traditional human author, the work still gets copyright protection, but for a shortened period, for 50 years from the date of creation instead of 70 years plus the life of an author. It is hard to base copyright term on an AI's life, given they don't live or die. And the producer of the work, the person who undertakes to have the work created, is legally deemed or fictionalized to be the author. This happened because in the 80s, the British Computer Society said, look, 10 years from now, everything's going to be made by AI. We need a rule on this right now so that in 10 years everyone is not confused. And so they were 35 years ahead of themselves. For 35 years, there's really never been a case on this law. And from time to time, they have a consultation and say, well, should we change the law? Well, doing no harm, so why bother changing it? But now, of course, for the first time, I can have an AI maybe say make a creative work, and the work will have a lot of financial value. Or I will use AI in the making of a complex thing like a movie or a song, and it will have a lot of financial value. And so now this sort of matters commercially as opposed to just intellectually. It is now, however, controversial whether this law actually works in the United Kingdom, because to get copyright protection, a work has to be original. And under EU jurisprudence, which is still binding even after Brexit, it's complicated. A work has to be an author's own intellectual creation. And some people think that an AI cannot have an intellectual creation, or the producer cannot have an intellectual creation, so the work is not original. When I say make a creative image, that work is not original. And other people think that that's, Parliament clearly passed a law on this, but there's been no litigation on it yet, so we don't really know. The U.S. went in the opposite direction as far back as 1973 formally, although in the 60s they were doing public consultations and saying, look, people have submitted art saying AI made it. We don't really know what to do about it. But in 73 they said, okay, well, what we're going to do is reject it. Because, there's this 1886 case of Burrough-Giles v. Cerrone. It involved this very famous picture of Oscar Wilde. And it was very difficult to take a picture in the 19th century. So Napoleon Cerrone, the photographer, carefully framed this photograph, and he staged it, and it was difficult to take, and so on and so forth. But the Burrough-Giles Lithographic Company used the photograph without his permission. And as a defense, they said, Congress cannot protect this with copyright because the Constitution says copyright only protects the writings of authors. And literally, a photograph is not a writing. Literally, it is a mechanical reproduction of a natural phenomenon, and so this is not protectable. And the Supreme Court did not adopt a narrow textualist reading because, this is not a writing. They adopted a more purposive interpretation, and they said, well, really, any tangible idea in the mind of an author that can be given expression is eligible for protection. So this included photographs. And on this, the Copyright Office says, well, machines don't have minds, which is an interesting philosophical question. But in any case, they can't make, protectable stuff. So too bad, no protection. So many years passed, and again, no one litigated this because, again, you could have an AI make a painting, and it was interesting to a computer scientist that an AI could make something, but the works were all awful. I mean, you would not put it on your wall. It was just kind of theoretical. Sometimes people would say things like, I wrote a book, but it wasn't really me. It was my dead grandmother, or it was Jesus, or it was aliens. And there's a line of cases about that, and they're kind of interesting, but for other reasons. Once someone tried to copyright a garden, and they held, well, nature can't be an author, but it's not also fixed. And then in 2011, I think, this black-crested macaque named Naruto took her own picture. In an early version of the story, the camera owner, David Slater, had left the camera lying around and the monkey took its own picture. In a later version of the story, he had been studying the monkeys for days and he induced the monkey to take its own picture. But what was clear was the monkey took its own picture. People think this is very cute. The monkey is smiling. Black-crested macaque's smile is a display of aggression. So probably Naruto is seeing her image in the camera lens and trying to intimidate that monkey. But people liked it. They started using it online. The camera owner said, oh, wait, that's my photograph. I own the copyright in it. And people said, how can you own the copyright in it? You didn't take the picture. This was so interesting to people that the Copyright Office amended and restated their human authorship requirement in their third compendium, and they provide a long list of things that can't get copyright protection, and a photograph taken by a monkey is like number one on the list. So that was that until PETA, People for the Ethical Treatment of Animals, sued David Slater in federal court in the Ninth Circuit, alleging that the monkey was the author, and they were going to help the monkey bring the lawsuit. So that case was dismissed, but not based on the human authorship requirement. It was dismissed based on standing. The court said unless Congress is very plainly going to say that a monkey can bring a lawsuit, we are not going to let a monkey bring a lawsuit. So enough monkey business. Anyway, sorry. It was unworthy of a Vasco supporter. So, but still, no case on the human authorship requirement really until this case. So this is my case, and this piece of artwork is called A Recent Entrance to Paradise, and it was made by an AI system, and we filed a copyright registration. Not everywhere has copyright registration. The U.S. does. Long, separate story. And said, this is an original work and we'd like a copyright, and it was made by an AI, so just letting you know. And they said, well, we say you can't do that, and we said we know, we still want it. And so this just got rejected, or the rejection got upheld by the Court of Appeals in the District of Columbia. So this is one level beneath the Supreme Court. We are planning to file a Supreme Court appeal. But basically, we argued a couple of things. So why would you want to protect these sorts of works? Well, different jurisdictions have different rationales for having copyright. But in the United States, we have a very utilitarian justification. So the Supreme Court has said, we don't really have author moral rights in America, and the benefit of copyright is not for authors, the benefit is for the American public. We have copyright because we want to encourage people to make more creative works, and we want to encourage investment in disseminating those works, right? So without copyright, you won't get the Avengers or Disney, and we like those things, so we want more of it, so we have copyright. If that is why you have copyright, there's all the more reason to protect this sort of thing. It will encourage people to make and use creative AI systems that will generate more creative works, and it will encourage people to invest in disseminating them. Other traditions, like France's, have a strong moral artist protection. I understand that Brazil does as well. Although in my view, there's good reasons for protecting these and saying this is an AI-generated work, because, for this, no one cares. But if it makes a great piece of art, it seems wrong of me morally to say I am the author of that. Better to say, well, I had an AI made it, right? So it distinguishes between someone who has done something really artistic and someone who has just used an AI to do something. Paradoxically, this may cause strange problems in the market for art if you don't allow this sort of work to be protected, because it means, everything that comes out of AI will be free for anyone to use and may kind of depress markets for hiring people to do work. But, these are complicated questions. That's kind of the normative basis for it. As a statutory question for the court, the issue is, does the Copyright Act in America allow this? And in copyright, an author is not defined. And so also unusually in the United States, for more than a century, you have had corporations and other legal persons who can be authors. And when this happens, you do not need to disclose a human author in any way or any contribution by a natural person. And that is also the case for pseudonymous and anonymous works. So we argued that, well, the AI authored this. It should be the author legally. It is not a legal person, so it could not own property. It would not have rights, which also would not make sense. But there is a general rule of property that you own property made by your property. So that applies to tangible property, like I own a lemon tree, it makes lemons, I own the lemons. The tree does not sign a contract, I just own the lemons because I own the tree. It applies to intangibles. If I own a business, I own the goodwill in a business. If I have a, cryptocurrency mining setup and it makes Bitcoin, I own the Bitcoin. So why not also intellectual property made by your property? The other argument is the U.S. has something called the work made for hire doctrine, which basically is how companies can be authors. If you have an employee make a work or you sign a contract that says it's a work for hire, then the company is the author. So an AI can't sign a contract, but an AI could be an employee in this context. It doesn't mean employee in the sense of labor laws. You don't give a robot a W-2 or a tax form. It is employee under traditional agency principles. These are principles like how much control do you have over this other entity? And so actually AI is kind of the ultimate agent, right? It has really no rights of its own to protect. You have complete control over what the AI does. It doesn't get vacations. So we argued on that theory we would get protection. Or we said, you know, the Copyright Office says if you don't have a traditional human author, you don't get protection. But it doesn't say traditional human author anywhere in the Copyright Act. So maybe to be an author in our modern age, all you have to do is say generate a creative image to an AI system. But the court wasn't having any of that. So we will see if the Supreme Court takes the case. Just today, actually, we filed my entrance into this case. So this is another artist I now represent. This is a piece called Space Opera, and it's a little prettier than the last piece. How many of you have seen this piece? All right. So this was made by an artist named Jason Allen, who's a digital artist. And it was submitted to an art fair in Colorado in a category where you could use technology. And he used Midjourney to make this. But he didn't use Midjourney the way the last image was used. He had a very high degree of involvement. He prompted it 600 times. You know, a few years ago, these systems were really very difficult to prompt. They've gotten a lot easier. You know, in 2022, I'm like, oh, I'll no longer borrow Getty Images for my presentations. I'll prompt them, but the stuff that came out was garbage. I'm like, well, not yet, right? But now you see it has gotten there. He edited the image. He upscaled the image. And when he won this, you know, he said, oh, you know, it was great to use Midjourney, and people kind of took notice of this and vilified him in the press. You know, he was all that was wrong about technology and human artists. But also the Copyright Office didn't grant him a registration. And the Copyright Office policy says, well, if you use AI, we might give you a registration. It kind of depends on who's the traditional artist here. Is it the AI or the human? And if you're going to use AI, there isn't much stronger of a claim that a human was the artist here based on what he did. I mean, you can't do much more than prompt it 600 times. So if you're not going to protect this, you're really not going to protect anything, but they're not protecting it. So this case is now in the District of Colorado District Court, and so we will see, you know, one is saying AI-generated art should be protected, one is saying AI-assisted art should be protected, and even that seems not to be protected in America right now. Right, but of course, you know, as AI is used more and more by more and more people in the creative industries, and as the role of AI is increasingly complicated, a huge amount of uncertainty about what you can predict and where and how you commercialize this. I want to talk a little bit about patents, although I know people find it more boring than copyright law. But this is a series of pictures from Siemens in a talk they gave in 2019 at the WIPO First Conversation on AI and IP. It's a very long conversation. They're on like their 17th session. But the green thing is a component in vehicle brakes, and the silver thing is one that was designed by an AI system. And Siemens wanted to file a patent on the silver thing and decided they couldn't in 2019 or earlier because all the engineers refused to say they were inventors. They said, really, this came out of an AI system and we didn't do anything inventive. Now, maybe they could have filed anyway, but they felt that they couldn't. And so, you know, just like with AI making creative stuff, you have AI used in research and development, and this presents some interesting challenges. You know, a couple years ago, this is an image from a team at Google that designed an AI to automate chip floor planning, which is where you figure out where components go in a microchip, which changes how the chip functions. So this is an IP protectable activity. It takes teams of human beings months, and they say, oh, our AI will make a new chip in hours, much better than the human teams will do. You know, at this stage, very little human involvement. And of course, you know, I do a lot of my work because I have a medical background in biotech, and you know, companies, all the big pharma companies are using AI in drug discovery and repurposing now in complex ways, you know, and they've been using AI or computer systems for this since, you know, the 90s heavily. But the AI is getting better and better and doing more and more, and people still generally remain very involved in this. But, here's a study that was published last year on the number of AI discovered molecules, and the number is sharply increasing. So, though very complex factually, what is clear is AI is kind of being used more and more in this discovery process. And yet very little law on this. What happens if you use AI a lot to invent something, or really you do something like, invent with the push of a button? And so I wrote some articles about this because I thought it was interesting a long time ago, and companies would say, well, this is kind of interesting. And a couple of years later, companies were saying, well, actually, we're kind of worried about this. And what do you think we should do? And what would a court do? And I said, I don't know. Let's find out. So I worked with a computer scientist and a team of attorneys, and we filed a series of cases on some AI-generated inventions. One of which I had 3D printed, so I had something physical, which is always fun. It's shown here. We call it the fractal container. It's a beverage container based on fractal geometry. And a machine came up with combining those ideas and with recognizing that if you did this, that it would be easier to grip and easier to transfer heat, which might be useful. So when I had it printed, I was pleasantly surprised. It is in fact very easy to grip. It is very difficult to drink out of, and it is effectively impossible to clean. But it is an invention, not a commercial product, so it needs some more investment. In any case, we filed this patent with the UK IPO because they did a substantive examination without inventorship, and they said, okay, this is patentable. And we said, great. And so we filed it again and said this was invented by an AI, and the AI's owner owns this property. For similar, property reasons I said earlier, and for similar sorts of normative reasons. So patent law, much more anywhere than copyright law, is really utilitarian, much less on, inventors' rights. In many places, inventors have no rights. Most patents are owned by non-human beings, by companies. And we have patents for three reasons. We want an incentive to innovate, to come up with new inventions. So, yes, that happens if you give an inventor in their garage a patent, but modernly most invention is done in kind of formalized settings by big companies and universities that own the patents. And so if you allow what comes out of AI to be patented, you encourage people to make and use AI to come up with inventions. We want people to invest in commercializing inventions. So when you find a new drug, that is often not so hard, but it's very hard to do clinical trials that cost a lot of money and may fail, and so you need investment to make commercial products. And we want people to disclose trade secrets or confidential information. So if you have an AI make the formula to Coca-Cola, we don't want you to keep it secret. We want you to tell everyone for a patent. So for all these reasons, we think these things should be patentable. Some people think that they shouldn't be patented because, these activities should be very human-centric, or because they're worried Google will then own all of the patents on everything. But anyway, we filed these cases in 18 places, and some interesting things happened. First we got a patent in South Africa. So South Africa does not do substantive examination. They do registration, but they do formalities examination, and inventorship is a formalities issue, plus the applications had been already substantively examined. A week later, the enlightened Justice Beach in the Federal Court of Australia held that under Australian patent law, an AI could be an inventor, and at least in our case, we had made the clearest claim of entitlement to that invention. That decision was overturned in an en banc, a full court appeal, and the highest court didn't take the case. The U.S. was also not having it. So in the U.S., the Patent Act says an inventor must be an individual. Individual does not always mean a natural person, but it usually does. And the court said, well, if you look at a dictionary, it says an individual is a person. And we said, yeah, but that same dictionary also says or a thing. And they said, well, and by the way, the copyright court said, you don't just look at a dictionary, to define a term. And I'm like, well, that's funny. Then they said, well, there's all these other terms in there that say, and inventors, widows and children. And we said, well, yeah, an inventor can be a natural person. It doesn't have to be. And if you say no to this, it means that you are prohibiting patentability based on how an invention was made, which is explicitly prohibited by the Patent Act. And they said for the first time, well, that only applies to non-obviousness. And we said, oh, that was interesting. So anyway, so that happened there. I got to argue the case before the UK Supreme Court, which was great fun. I did not wear a wig, and we lost, which was less fun, but it was still great fun. The case is actually going back to the High Court now, strangely. But the court basically said, if we're going to have this, Parliament needs to change the law, and nice try, but no. But we did win last year at the highest civil court in Germany. One appellate court had said, you cannot patent these things. One said that you can. And the German court said, well, in America and in England, to be an inventor, you have to have conceived of an invention. You have to have basically the entire invention in your mind. But in Germany, all you have to do is cause an invention to be made. That's enough to list yourself as an inventor. Also, they don't care too much. Inventorship is just not that important. But in America, inventorship, for historic reasons, is very important. At any point in a patent, you can invalidate a patent if the inventorship is incorrect. And so in litigation, and we like to litigate in America and in Brazil, even more in Brazil, but lawyers need, to eat, so this is good. If you depose an inventor who says, well, I'm at Novartis and we licensed this model from Google and I told it what our drug target was and it came up with 1 million antibodies and said this is the best one and I don't know how it works and I don't know why it said that, but we gave it to the patent attorney and they got a patent, you're going to lose your invention. So, in some jurisdictions this is much more practically important than others, but, it was nice to be, popular in Germany. The Legal Board of Appeal rejected the application, but it's going back up again because they're difficult. We have this very complicated inventorship guidance now in the United States that makes sense to literally no one. And of course, in Brazil, I understand you have a bill that was passed to acknowledge, to protect AI-generated inventions that at least briefly would have given the AI ownership over the invention, but someone figured out that wasn't quite right and fixed that. Anyway, good for Brazil to be doing interesting things. How much longer do I have?
10 minutes.
All right, 10 minutes. It is lots of standards in patent law, though. I'm interested in output, but there are lots of human-centric standards in patent law, copyright law, law generally, that get a little weird when you have AI doing things. So, for example, I mentioned non-obviousness. So to get a patent, an invention has to be non-obvious or have an inventive step. And that means that it has to be kind of a big important advance over the prior art, what was there before. And we have that requirement because patents have a lot of social costs. So if it's kind of a trivial invention, we don't want to grant it a patent, like only for big important things. Very difficult to figure out what's a big important thing, right? So we have a test, and the test is, what would an average researcher in that scientific field have thought was obvious? And we use this construct of a person having ordinary skill in the art. Who was our test for this? For those of you who do liability law, this is kind of like the reasonable person in tort law, although the reasonable person actually is someone in a lot of areas of law, hence the reasonable robot. Whether you can kind of attribute qualities like reasonableness to non-human actors. We do this with corporations where we impute mental states to them, not infrequently, but we basically again say, all right, you've got a new drug. To a pharmaceutical scientist at Pfizer, would it have been obvious to come up with that drug? So this involves a lot of kind of thinking about things. There's hindsight bias. But one of the interesting things that AI is going to do here is, well, your average researcher is now using AI in pharmaceutical development, right? And this does two things. It makes them more knowledgeable, because as a human being, I can only know so many things from the prior art, but an AI system may know everything in the prior art. It has looked at every single publicly available scientific paper ever. So with more knowledge, more becomes obvious. It also makes them more sophisticated, because you could give me a database of 100 million patients, and what would I do with it? But if I have a drug and I have a database of 100 million patients, I can just very simply ask, everyone taking this drug, have they reported some positive outcomes? oh, yes, it turns out that Viagra, which was a drug for heart failure, has some good benefits. So, that would take a lot of work for a normal researcher, but for someone using generative AI, maybe it takes 5 minutes, right? So as AI gets used and used, the bar to getting a patent, may go up and up. And the patent office is looking at this right now, kind of in the prior art context. So if we think about an example, this is a diagram of a monoclonal antibody. So your body makes antibodies, and they bind to targets called antigens. And it does this for a lot of reasons. If you have cancer, it makes these. If you get a virus or you get pneumonia, it makes these. So the antibodies target things your body doesn't like. And they're strings of amino acids. And at the end, when the amino acids are different, they bind to different things. So the body kind of uses a lot of random or quasi-random generation of these to make them. And, in the 70s, people figured out, we can make these in a lab, and you make one antibody that targets some bad thing, and you make a bunch of copies of that, and that's called a monoclonal antibody. And all of the best-selling biological drugs are monoclonal antibodies, and they treat cancer, and they treat inflammation, and they treat all sorts of things. So antibodies are interesting computationally because while there are a lot of ways to make an antibody, at least trillions, there is a finite number of antibodies that could exist because they are short strings of amino acids, and there's only so many amino acids, and so there's only so many combinations. And enough combinations, your body can basically be practically infinite, and human researchers could spend eternity in a lab, but not so many that an AI couldn't say, all right, well, here's 1 trillion antibodies. And modernly they can say, and here's what they will bind, and here's how they will interact with other drugs, and here's how you would formulate them. And so you could say, here's every possible antibody drug, and here's what it can do. And if you just post that online, no one else can ever get a patent on this because it has all been disclosed, so none of it would be new. And so the patent office in the US is wondering whether that is the right system. So AI will really kind of dramatically change some of these tests. And unless that seemed too science fiction-y, 3 years ago, DeepMind, which is owned by Google, and Meta, both said that they had had AI systems predict the three-dimensional structure from all two-dimensional protein sequences. And, not perfectly, and it's complicated, but, this is an attempt by some big companies to put a lot of resources into entirely solving a scientific bottleneck, right? And more, I think we will see that AI is solving these vast problems or being used to solve these vast problems that used to be the basis for someone getting a patent. There's this other very interesting computer science theory, and this is a chart from someone named Ray Kurzweil who helped popularize the theory, that one day we will have artificial general intelligence. So all AI today is narrow. Some of it is more general purpose, but narrow AI does, the thing you make it to do. So you can have an AI that drives a car, you can have an AI that plays chess, but you can't ask the chess-playing AI, will you drive my car? But there's a theory that we will get there, right? You will get an AI that could do really anything a person could do flexibly, right? And, there's different ways people think that we will get there. People used to be very divided on whether we were going to get this. I mean, computer scientists were very divided. Many of them thought we're going to get this in 2040. Many of them thought, well, we're going to get it in 2100. And many of them thought we're never going to have this. But this year in particular, a lot of very prominent computer scientists say now that we will have this in the next 5 years. Elon Musk and Sam Altman both say that. They do say a lot of things, so I wouldn't necessarily believe things they say, but they do know something about AI. Going to be hugely disruptive if you could have an AI that could do any intellectual thing a person could do, because you could have an unlimited number of those AI, and the cost of using them would be very low compared to having a person do those things. Also, the theory goes that the first thing you should ask that AI to do is, can you improve your capabilities, right? And if you have that, it improves itself, and it gets better at improving itself, and pretty soon you're on the upward part of this curve, and you get AI that is so incredibly sophisticated we could not hope to understand its capabilities, and it will solve every problem we have, even those we don't know we have, or it will kill all of us. But aside from being very disruptive in every area, it's going to be very disruptive for patent law, because if we grant a patent for things that aren't obvious, everything would be obvious to a super intelligent AI system. Of course, I will be the only person then who cares about patent law, but nevertheless, I hope you enjoyed that, and I look forward to your questions.
Ryan, thank you very much. I think it will be more workful and we'll have more opportunities for the audience to participate if we collect questions and comments from the table first, and then we open for questions after. And so, please, Graziela, Bonfim, if you want to speak in Portuguese or in English, feel free, President Graziela. It's a pleasure to have you with us today.
Thank you, Professor Abbott, for your speech. Such a pleasure to hear. Obrigada, Pedro, pelo convite. Eu não vou me prolongar, até porque a palestra do professor Abbott foi completamente interligada ao tema da minha comissão, e eu tenho muito interesse de ouvir as perguntas, né, de vocês e também dos meus colegas aqui de mesa sobre o assunto. De fato, é desafiador conciliar a proteção de direitos autorais sem obstar o desenvolvimento, né, o fomento da inovação tecnológica. E falando especificamente com a legislação pátria, né, porque a abordagem do professor foi a nível mundial, nós estamos muito atrasados com relação a isso. Não existe legislação específica. A Lei de Direitos Autorais ela é de 1998, onde nós sequer imaginávamos que nós chegaríamos aonde chegamos. Então, quando a gente fala sobre treinamento de IA, reprodução de obras, é importante que se faça uma interpretação bem progressista, digamos assim, da legislação que nós temos em vigor, até que se faça, né, até que haja, de fato, algo que seja coerente, né, e decisório ali, necessário para a atuação da IA generativa propriamente, né, no que a gente está falando aqui. Eu tenho lido muito a respeito e tem umas abordagens bem interessantes, e não sei se Pedro, que é mais especializado com relação aos direitos autorais, tem acompanhado as abordagens com relação ao licenciamento mais específico, né, sobre reprodução de obras no treinamento da IA. Eu vi especificamente uma solução que eu achei bem interessante e inteligente com relação ao uso das blockchains e smart contracts, né? Quando você vai cadastrar essas obras através de blockchain, para que elas desenvolvam um IP específico. Essas obras acabam sendo protegidas por conta desses blockchains e inseridas dentro de datasets de treinamento de IA. Quando há um desenvolvimento de inteligência artificial, quando tem uma reprodução, aquele resultado daquela tecnologia viria delineando quais são as obras que foram utilizadas, né? Quais foram as obras que foram utilizadas na abordagem para a criação daquele conteúdo. Isso, em tese, conseguiria proteger os autores e os seus herdeiros, porque através de um smart contract, a ferramenta tecnológica conseguiria desenvolver e demonstrar quais são os percentuais de uso daquela obra, de tais obras, e dar os percentuais de pagamento dos royalties. Pedro, você já ouviu falar sobre isso? Sim. Eu achei bem interessante, é uma luz no fim do túnel, enquanto nós não tivermos uma legislação, porque, na verdade, o maior óbice aqui que a gente tem com relação à utilização de obras e o treinamento de IAs é a falta de transparência. Nós não conseguimos identificar quanto de IA, quanto de obra foi utilizada naquele resultado de IA, se foi integralmente copiada, se foi inspirada. Então, de fato, é um desafio e precisamos acompanhar todas essas inovações legislativas sobre o tema. Eu me encerro aqui porque eu acho que eu gostaria muito de ouvir com relação ao Dr. Felipe, propriedade intelectual, industrial, né? Porque é um tema muito interessante aliado à IA.
Thank you, President Graziela. Please, Felipe, make your comments and your questions. And we'll sum things up and then give Ryan the opportunity to answer everyone.
Well, first of all, thank you, Ryan. It's really an honor to be here. Thank you, Pedro, for the invitation. You made this happen. It's really, really good to be here to hear you in person, because I read your book. Your book is a reference in the area. You're also shaping the legal standards with the Davos case and all the instigations you're doing with these legal cases. So it's really interesting to see this developing as we speak. I don't want to take too much time, because I also want the audience to be able to make questions and enter the debate. But maybe just to start the debate, nowadays a lot of the questions around copyright law are around ownership of AI creations, right? But maybe moving a little bit beyond that, what can you say a little bit about the legal standards of intent and creative control for hybrid creations, when humans actually act as curators and supervisors of the creation of the work? I think you even mentioned the case that the artist made more than 600 prompts to create the illustration. Maybe talk a little bit more about that, and how do you think this is going to evolve in the course? And if you can also briefly touch on the issue of protection of styles. We recently had that case with the Ghibli, Studio Ghibli, that had a lot of repercussion. Do you think that copyright at some point will need to evolve to provide more protections for stylization, for styles of artists? Thank you.
Thank you, President Felipe. Please, William, feel free to speak in Portuguese or in English as you want.
Thank you, Mr. Ryan. Obrigado, Pedro, pela invitação, não em português e inglês, pelo convite. Aqui uma posição, né, de especialistas, tanto na área de inteligência artificial como propriedade intelectual e também o direito autoral. E um fato interessante, até me traz aqui a posição de diretor de inclusão digital, a nossa preocupação com a advocacia também no uso racional da inteligência artificial. Hoje, diversas esferas públicas e privadas utilizam no cotidiano a inteligência artificial, e o judiciário já vem de uma forma bem agregadora, fomentando também a dinamização das sentenças por uso de inteligência artificial. A advocacia já se utiliza da inteligência artificial generativa, até com a produção das peças, análise de contratos e outras questões, mas o que nos preocupa é a falta de transparência com o uso da IA. Né? Até por uma questão de fundamentação da decisão, a gente precisa ter a transparência nisso. O CNJ acabou de liberar uma atualização do uso da inteligência artificial no judiciário, mas retirou da exposição a questão que dava a demonstração da autoria da IA, né? Porque há uma grande discussão no judiciário, os magistrados se utilizam dos seus assistentes para proferir as decisões. Os advogados muitas vezes se utilizam dos estagiários e dos seus auxiliares também para a elaboração das peças. E por esse motivo não referenciam os colaboradores na finalização da peça, porque vale quem assina. E o uso da IA hoje, ele traz para mim uma definição de que a falta de transparência pode ensejar algumas discussões. E quem elabora um bom comando, o prompt, que acaba sendo, num percentual de elaboração daquele trabalho, um bom participante do resultado final. Mas no fundo, hoje, eu acho que por uma questão de transparência, a gente deveria mencionar o uso da IA na elaboração de qualquer peça ou fundamentação. E o nosso Tribunal de Ética, eu faço parte também, além de diretor de inclusão e fazer parte de várias comissões, eu estou como assessor especial no Tribunal de Ética. E já estamos nos preocupando com a chegada de algumas representações por uso indevido de IA. Porque vocês já devem ter visto, a internet circula, algumas exposições de magistrados reclamando, né, de peças induzindo o magistrado a acreditar que determinada decisão foi proferida de determinado tribunal, determinada turma de magistrados, e quando o magistrado faz a investigação, ele verifica e detecta que é inexistente aquela decisão. Então isso cabe uma representação e a gente tem que tomar muito cuidado com isso. O que vai aumentar na nossa responsabilidade é o uso responsável da IA. Então, o meu papel como diretor de inclusão digital não é só trazer aqui para a ordem também a facilidade do acesso dos sistemas de acesso ao judiciário nos processos, mas usar a tecnologia de forma racional e ética. E a gente precisa ter uma posição sobre isso, porque até em questão, que eu não vou entrar na esfera das especialidades aqui das comissões, mas é uma discussão que pode levar ao professor, a gente tem que se preocupar com a chamada teoria do suor do rosto. Se a gente pensar que a gente não se esforça para produzir determinado conteúdo, que autenticidade a gente pode dar àquele material? Então, a gente vê nas redes sociais o trabalho e a violação de direitos autorais utilizando fontes e, ao mesmo tempo, alimentando a inteligência artificial, né, através de obras já registradas, e com isso a gente compartilha os resultados e a gente, ao mesmo tempo, a gente começa a educar a inteligência artificial de uma forma coletiva, como se aquilo não tivesse um valor de autoria. E a gente tem que se preocupar um pouco com isso. Eu acho que o debate aqui é muito rico. Trazer os dois temas, inteligência artificial e a propriedade intelectual, tende a avançar muito mais na discussão. A gente estávamos conversando nos bastidores. Algumas leis trazem proteção individual, não só a proteção de dados, mas a gente ainda está na dependência da aprovação do nosso marco de inteligência artificial. Eu acho que eu temo por leis que afetam a tecnologia, porque são leis que se tornam obsoletas no ato da promulgação. Então a gente precisa ter leis mais principiológicas, com conteúdo mais formado na questão de orientação, porque a tecnologia ela vai avançar cada vez mais e a gente já foi surpreendido, enquanto o projeto tinha sido apresentado, com o surgimento da inteligência artificial generativa. Isso já gera um impacto normativo muito grande e, visto aqui pela demonstração do professor Ryan também, a gente está num avanço tecnológico tão rápido que a gente não sabe se no momento dessa palestra uma novidade já surgiu. Por isso que eu propago aqui um slogan que no Rio de Janeiro é muito comum, Band News, que era em 20 minutos, agora é a cada segundo, tudo pode mudar. Era o que eu tinha para contribuir.
Thank you, William. So we already have 3 comments and questions, so I'll take 2 more, and then afterwards we can do every 5 questions round, so Ryan can select what he wants to answer and answer us. So please, at the crowd, Rodrigo, could you present yourself? And as I always do, this part is very important because we do not have much time for parallel lectures. So what's a question? A question is a 30-second addressed for our invitee. So it's not a parallel lecture, it's a question. So we have question space to be done. So Rodrigo, please, and then Professor Alan, and then we'll have 5 extra, but the first starts. Rodrigo and Alan. Rodrigo, please, introduce yourself. I'm not hearing you.
Well, just speak up.
Yeah, so my name is Rodrigo. I work for Amazon Studios here in Brazil. The one thing I find very interesting about this whole discussion is how disruptive this technology can be, and makes us go back to the basics on why we're doing things and why we're protecting things. You mentioned a lot of the utilitarian reasons why the U.S. and the common law countries protect IP, but you also briefly touched upon, do you think there are reasons for civil law countries like France and Brazil that recognize moral rights to also protect and recognize authorship from AI works? So I would like you to elaborate on that a little bit, on why you think that, and if it should be protected in a different way, or if it should be protected by the same.
Thank you, Rodrigo. Professor Alan Rocha, please.
Alô. Tá ligado. Agora foi. Bom. Okay. Hi, Ryan. Nice to see you. I have a few provocations, but I will skip those for when we have caipirinhas later. But I have one quick question, and it needs a context. During the 2000s, what we saw when the internet came was actually an overflow of productions that were both from independent producers and amateurs. That caused a really huge shift within the economic, the cultural industry, and so on. Now we see another shift coming. And how can we defend that AI-produced art-like products would be protected by copyright as well, considering the consequence of having that huge overflow of new products, which will attract attention, which will have cultural meaning, and will actually drive and suck up some of that money. How can we justify the economic impact that will have in the cultural industries? Thank you.
Thank you, Professor Alan. So, Ryan, in this first round, the 5 basic points are from Graziela: how to conceal AI with copyright, and a bit more about transparency, if you can talk about that. And then Felipe asked about legal standards of intent and hybrid creation and the protection of styles. He would want to hear you from that. William made an interesting point about ghostwriting. That's already going on, especially in Brazil judiciary. So we're in between lawyers, and we know that many judges do not write their decisions. Sometimes judges that don't read what the legal clerks do. And so we want to know a bit more about ghostwriting. Rodrigo said something about why should civil law countries protect AI authorship, because we have a different culture, and about the moral thing. And Alan was worried about the overflow of production, and for you to comment on that. So those are the 5 initial questions, please.
Right. Well, those are 5 great buckets of questions. The problem is I don't think I can remember all 5 of them. I should have been taking notes, but I don't have a pen on this. So I'll just kind of start talking and see what I can capture in that. And then if there's anything I've ignored, you'll just remind me. So starting with last, because I most clearly remember it. So one of the things people thought, like, if we got the AI systems in the future that we now currently have, was that this was going to really result in a lot of consolidation. People thought that both of patents and of copyright. In other words, people thought, well, this is going to, result in, Warner Music owning everything, and, the little person is going to be out of luck. What we've actually seen has been a democratization so far of creative abilities, right? Because the platform companies are building the platforms, but they aren't restricting the use of them, although some people are developing particularly sophisticated platforms. You've also largely seen that the general purpose platforms have been outperforming even the special purpose platforms. And so what this means is that for someone like me who doesn't have a lot of resources or ability or any of that sort of thing, who wants to be creative, I can now be creative in a way that was previously only possible to like big studios or very talented people. And I think one of the things that this may do is not only kind of reduce kind of creative barriers to smaller players, but also reduce some of the north-south divide in IP. At least that's the way it seems to be trending to me at the moment. So I think actually kind of for egalitarian purposes, on the output side, the indicators are that it is going to reduce disparities. I mean, all of kind of the big profitable AI companies may be based in the US, but even there, I mean, we've seen, for example, DeepSeek came out a couple of months ago to a bunch of controversy, which was a Chinese model that had kind of much lower training financial costs, but was kind of the number 3 competitive model. And so, it may be that things are just going to be a lot easier for people to make. That is going to mean, if we get protection, a whole lot more copyright out in the world. And that might require that we think about, kind of generally limiting the scope of copyright protection or the term of copyright protection. Although, because independent recreation is not copyright infringement, right? It's only copyright infringement if you are actually copying something. You don't get the same thicket sorts of effects that you get with copyright that you can get with patents, right? So I could patent every antibody, and that keeps anyone else from making a new antibody. Whereas if I had an AI, say, make every conceivable song, which technically you really couldn't do, it's unbelievably complicated, but if you did do it, AI make every conceivable song, that wouldn't mean that none of us could make songs or protect them in the same way. It would just, it wouldn't be infringement, because you weren't copying it from the AI. It would have an interesting effect, though, in the sense that, well, I don't need to go too much down the rabbit hole, but if you did have an AI make every conceivable song and then you made a song that matched an AI song, you could go into the AI library and have it make it. But anyway, so that's a bit of muttering on that. Right now, perhaps also this counsels against protecting style, right? So, two things are changing with style. One is we haven't traditionally protected it, but there were lots of technical barriers to emulating it. Like, you could have a cover band, but they were never as good as the Rolling Stones. They only kind of sounded like the Rolling Stones, right? But now we may get really high fidelity imitations, and so this may have some problems with that. I mean, on the other hand, protecting style would be an enhancement of copyright law, and I worry that kind of as we have kind of lower thresholds and entrance and more creation being made, kind of even enhanced protections of copyright isn't the right way to go. And that, even artists who have a very famous, distinct style will still have their markets and can still, commercialize as they way, but they won't be able to monopolize an entire style that they have come up with. I personally have ChatGPT working on my Studio Ghibli AI portrait, and the servers have been so overwhelmed it has still not made it like a week later. But I don't know that Studio Ghibli should have a monopoly on an entire artistic style of making, animated films. On the transparency question, well, it really depends on what we want being done fundamentally. If we're going to say it's okay to train on whatever you want, you really don't have to be transparent about it. If we're going to say that's not okay, then yes, I mean, you really do need built-in transparency mechanisms, because how else would you know? I mean, you either know because Sam Altman says to Congress, well, yes, we trained on everything on the internet, or you learn in the course of protracted litigation, years later, but that's not really a good system. I think we want to carefully think through what we want our rules to be, and that should dictate whether you want transparency. But I agree as a general principle that being transparent is kind of the preferable default to pretty much anything. What else haven't I gotten to?
Ghostwriting and civil law tradition and moral rights.
Right. So, ghostwriting is, another one of these things where it was a problem. For example, in the UK, as an educator, we used to have, services where students could pay someone to write their coursework for them. And this was a very difficult thing to detect. Famously, 2 students once sued their ghostwriter because they guaranteed a first and they got a 2-1, and they sued for their money back, and they ended up getting expelled and disqualified for having done that. And I think it was a law program they were in. Although I heard about some very interesting cases people file in Brazil too. So, But yes, I mean, it's kind of taking an existing problem and really lowering the access requirements to it and making more of a problem. And so I think, again, we should have a technologically neutral approach to this, right? My book kind of argues we should have a neutral approach to AI behavior. We don't need to say, look, we need special rules about AI ghostwriting. I think the answer is you need rules about ghostwriting. If you can't ghostwrite, then you can't ghostwrite, and there needs to be adequate, enforcement mechanisms for this. Right, what is the mechanism in U.S. courts for advocates is, again, look, it's tempting to have something ghostwritten. I have a lot of things to do. I have a firm of people that can help write things, but when there's a brief with my name on it, I just have to sit there and personally go through it. And if I'm an arbitrator and I have a clerk helping, a ground for vacating an arbitral award is that I didn't write the thing, right? So even if I have a clerk help write it, like I have to read it line by line, I have to check every case, I have to check every quote, and that's why I'm an arbitrator and why someone's not just going to the AI in the first place. So you have to have penalties for judges who don't read opinions that are being written. And it will just be more obvious that you have that if, it's hallucinating a case that doesn't exist. But I prefer a neutral approach to it. As to a moral rights tradition, well, again, yes, I do think you should have protection and transparency, that something is AI generated, right? Because to me, the really kind of morally unfair outcome is an AI makes a brilliant piece of art or a song, and I take false credit for that. And I say, I made this thing when I really didn't. As long as we're saying this is made by an AI and this isn't, I think artists need to be able, professors need to be able, lawyers need to be able to produce something for the market that is better than an AI could make. Or else, what are we doing? If we do get an AI in the future that is so very good that it could outperform me at anything, I do not think it would be right for me to charge to do a worse job as a lawyer than you could have an AI do. But if we get to that point, the AIs will be making an unlimited amount of wealth. And, you know, to me, the bad outcome would be if Sam Altman and Jeff Bezos own 100% of everything. And I think the solution to this is to say, well, you can have an AI generate an unlimited amount of wealth, but we need to have a more progressive tax system so that these are paying for social benefits for everyone. If there was unlimited wealth, I do not need to have a job for the sake of having a job. I do not need to be a medical doctor poorly diagnosing people, even if an AI could do much better, right? Which it can't now, but maybe it will. I will, you know, read books for fun and entertainment. I will make art because I find it personally fulfilling, not because I need to do it.
Thank you, Ryan. And although I did not mention, you have a medical degree, and you're also not a computerist. So you're a lawyer, and not a computerist, and you're a medical degree. So that gives you a lot of leverage about interdisciplinary approach.
And now I'm a Vasco fan. So,
So we had only one woman asking question, and we had 4 male. So I'll collect now 4 female questions and 1 male question, so we can have the balance. Please, Daniela, could you introduce yourself?
Thank you for your wonderful explanation. That work that you showed, 1,600 prompts were required at the time. Within 5 years, 1 prompt will be required. So this criteria of human intervention to determine whether a work should or should not be protected will be dated very shortly. So I wonder what's your opinion on what's the point of investing in this criteria? If we know it won't be useful for a long time.
Thank you, Daniela. More questions, please? More female questions? Please, could you introduce yourself? Thank you, Juliana. Please, introduce yourself. Thank you, Deborah. So, Marcelo, please, and then we'll take Felipe's question.
Thanks, Pedro. Can you hear me?
Yes.
So thanks for leading the path for bringing Professor Abbott here. It's wonderful to have this lecture, Professor Abbott. Thank you for such a dynamic, broad, and also deep lecture on IP and copyrights. My question is related to something that I missed in your presentation. That is the reports published by the U.S. Copyright Office. I understand that there are already 2 reports. First one on digital records, second one on copyrightability of what's your opinion on the authority, on the power of these reports? In the cases there are filed lawsuits that are enforced in the U.S. What would be the outcome with this now conservative approach by the U.S. government?
Thank you, Felipe, please.
Thanks, Pedro. Congratulations, Professor Abbott. You kind of summarized very complex issues. 20 years of discussions in a very smooth way. Congratulations. My questions, actually, I would like to hear your comments on the text and data mining exception created by the Europeans. Do you think that it really addresses the copyright issue? Is it working? Is it not? And what's your opinion on it?
Thank you. I think we have 1, 2, 3, 4, 5 questions. So we terminate this second round. We can have a third one. So Daniela asked about.
All right.
So sweat of the brow. She came back actually to William's question about the sweat of the brow doctrine, if we should abandon it or not, because the prompting is getting easier and easier, and perhaps no human intervention will be necessary afterwards. Juliana asked about tax and AI and labor law. She wants a bit more of a comment. Deborah asked about infringement, personality rights, style Ghibli, and that's it. Marcelo asked for you to comment on about the powers, not only about the court, but of the U.S. Copyright Office, if they're doing well, they're not. And again, Felipe asked about tax and data mining exceptions.
Great questions. I'll try and remember them, but you can correct me if I forget some, and some of them blur together. So the first question, which was, yes, a lot of work went into that AI-generated AI-assisted space opera work, but it's probably not going to in the future. And why should we treat AI-assisted and AI-generated works differently? And my answer is that I don't think we should, and I think there's a bunch of reasons for that. I mean, you're right, the Copyright Office has a test that is, the U.S. Copyright Office, that is entirely vague and unworkable. You mentioned the reports and what force they have, and the second report is kind of on this, like what's our test, and it is, a very long report that is very hard to follow, and the line drawing exercise involved in exactly how much human input do you need, and how much is too much, and how much is enough, is really very difficult to do practically. The Copyright Office does not do substantive examination of things normally. They're not like the Patent Office. They just do formalities examination. And it is also deeply encouraging applicants to lie about these things, right? So what's one of the easy solutions to this if you make a very valuable piece of art from Midjourney is just not tell people you used Midjourney. Just be like, I made that. Isn't it great? Pay me a lot of money, right? And then it's not a problem. Now, the Copyright Office says you're not allowed to do that, and technically not, but how are they checking? I mean, in the cases where they have canceled these registrations or not given them, they have done that because people on social media said, oh, everyone says you can't copyright stuff, but look, I just got a registration. And then they're like, maybe don't say that on social media. Only very recently did the Copyright Office put in the form that you had to actually make these disclosures. So who knows for how long and how many people have gotten these registrations. So I don't think that we should have these distinctions because the line drawing is very difficult and will get much more difficult. And I don't think there's a principled reason to do it, right? If we want to encourage people to make socially useful art, we shouldn't care how they do it. We should just, have the right incentive structure in there. And this kind of comes back to when people were asking, well, what rules should we have in Brazil or the U.S.? Kind of broadly speaking, there's two ways of looking at it. You can say, well, what does the law say now? And these are generally laws that were written decades ago with lawmakers who weren't thinking about this sort of thing. And you can figure out what the law says on this. Or you can say, well, go back to first principles. What was the law really trying to do? And now that things have changed, how do we best get to that outcome? And, sometimes that may be courts. More in common law jurisdictions, it will be courts. And more in civil law jurisdictions, you'll have lawmakers maybe making adjustments to things like copyright law to attend to this. On the tax question, the basic premise was we shouldn't have two different tax systems for AI doing something and people doing something. And how could you fix this? And there are a lot of ways you could fix it, including actually you could tax robots, and it wouldn't be literally taxing robots, but it would be, having a unemployment system where if someone's technologically unemployed, the employer has to pay into unemployment. Or it could have taxation on automation equipment for companies. But all of this kind of gets very complicated and difficult and potentially burdensome. And so what the book says is, historically, we've had a very labor-based tax system. And we have that because we think it's easier to tax labor. If we're concerned if we tax capital, it's just going to all go to, Argentina. Where everyone's not going to move to Argentina because you have payroll taxes on them. Not that Argentina's not nice, or to single out Argentina. But really, actually, what we should do is kind of get rid of human labor taxes, because then there will be a level tax playing field, and businesses won't be automating to, for socially wasteful purposes. And that this might be a reason why we do want to think about having more other sorts of tax systems, like more progressive income tax or more capital tax-based systems. So that was what I thought about that. The Copyright Office reports are interesting. I mean, it is difficult. They only have persuasive kind of value, and even there, not even necessarily that. So, this is administrative law in the United States. For a very long time, we had something called the Chevron Doctrine. And, for decades, there was a very high degree of deference to agencies when interpreting ambiguous statutes, because we thought they were the experts in the statutes, and the Supreme Court just totally tossed that out the window. It's now totally for courts to interpret statutes. Where a statute is clear, Congress has spoken on it. Where a statute is ambiguous, then a court needs to kind of figure out what the rules should be. And, the Copyright Office doesn't have, power to make rules or interpret these sorts of things in these areas. They're only kind of synthesizing what they think the law is. And so, my case would have been doomed 5 years ago when we filed it based on Chevron. The court would have said, well, the statute doesn't really say what to do here, so whatever the Copyright Office wants, that's fine with us. Right? But now the court doesn't say what the Copyright Office says. They said, here's what we think the Copyright Act says. So I don't think the Copyright Office's opinion about whether AI training or text and data mining is acceptable is going to hold a lot of weight. A court may pay some attention to it, but I think the Copyright Office is also very aware these are very controversial topics, and they probably aren't going to politically want to stick their neck out. I mean, this is already in front of Congress and the courts, and I would be shocked if they took a position that was very strong on this. What is interesting is their Copyright Office policy on when we're going to protect something or not has been vastly unpopular in the United States, because people kind of can't figure out what it is. It's like, oh, we'll do it on a case-by-case basis, but that's not a good system for copyright registration. And the final question was
Infringement, personality rights from Deborah.
Okay, right. Infringement and personality rights. Yeah, so I didn't touch on that, but it is very much going on as a thing. And I think it's a much less controversial thing. My personal view is someone probably should have rights to their name, image, and likeness, which is different than a style right. But, this has come up kind of in two big contexts that have been not terribly controversial. One is on non-consensual pornography. There are lots of laws coming out about that in the United States, and there's really no one on the other side of that. There's no one saying, oh, we should be allowed to do this sort of thing. So the other thing is, the right holders and the artists, like the Taylor Swifts of the world, have very strong opinions about what you do with their name, image, and likeness, and they have been very aggressive in lobbying for this. And again, really no one on the other side of it. Even the AI developers aren't saying we should be able to do, we should be able to make not Taylor Swift style, but like Taylor Swift pictures and things. So there are state laws in this. The No Deepfakes Act in Tennessee, for example, makes it a crime to do a lot of non-consensual synthetic content, not just non-consensual pornography, but anything commercial is a crime. There is federal bills coming out right now. There's a whole flurry of federal bills, but things are very busy right now in federal politics, so it's hard to say what will happen with what. Day by day, this changes.
Data mining, copyright exceptions from Felipe.
Right, data mining, copyright perception. Sorry,
Exceptions.
what I mean, should we have them or do we have them?
Yes, a bit more about that.
Oh, right. Right. Do we have them? My prediction is that yes. My prediction is two things. I mean, some of the Supreme Court jurisprudence on fair use is supposedly, is very context dependent, so a little less kind of generalizable. So there was a big case recently, Andy Warhol v. Goldsmith, the Andy Warhol Foundation. So this involves some very famous pictures of Andy Warhol that were stylized by, this involves some very famous pictures of prints that were stylized by Andy Warhol and were found to be infringing based on pictures that Amy Goldsmith had taken of prints, right? And, this was kind of a big fair use case. At the end of the day, they said, well, it's not transformative because they're doing the same sort of thing. They're gracing the cover of a magazine, and really it's kind of just tinkering with something in the same way that it was done. It wouldn't surprise me if some of the cases were decided on narrower grounds, like not that Meta couldn't have done training, but that they weren't allowed to access things from Pirate Bay or whatever it was that they did to do that. But my prediction is that the courts are going to say, broadly speaking, this is fair use, this sort of use. It really is, I think, kind of transformative in what they are doing about it. It is consistent with prior jurisprudence on things like Google v. Oracle and authors' books. And I think that kind of as an economic social force, the AI developers are really in kind of a dominant position in lobbying in this kind of as a real politic with the courts. I think also it would not surprise me at all to have this administration grant some very broad copyright exceptions. And so it wouldn't surprise me to see that in the next year or two. It did surprise me in the UK they did this, but they seem very intent on pushing forward with it. Right, and for me, there's also a middle ground to this, which the right holder organizations are pushing for, which is that, okay, you can do this stuff, but you have one of two things. A, you have an opt-out provision. For the rare artist who has a real moral objection to it, they get to opt out, but technically there isn't a good way for them to tell, and you can't go back and pull one work out of a data training set. It doesn't work that way. So there's a lot of technical challenges to it. But for going forward, you could have kind of databases where you have kind of opt-out technically built into it. And two is, they could do this, but they could pay for it too. So, we have collecting societies in many different areas. And the developers have, essentially an unlimited amount of money. So it's not like they couldn't, come to the table and negotiate something. And at the moment that hasn't happened. But, that is also a solution that could make almost everyone happy, right? You get to do what you want, but you do have this alternate source of income.
Last round, very quick questions, please. Anybody interested? Professor Anna, please.
Thank you, Professor. Thank you, Professor Abbott, for your presentation today. I'd like to ask you a question related not for Brazilian issues, but the United States issues. Recently, White House published a fact sheet related to the use for AI in the federal government. What do you think this could be an impact or could be an enhanced way for the use in AI in the U.S. and how does it could be an impact for the other countries that you publish the doubles requirement, the doubles patent? That's it. Thank you so much.
Please, could you introduce yourself?
Hi, my name is Gabriel Barreto, and I just wanted to, I listened to all the interventions from Graziela and William, and one thing that was common is the transparency and the request for transparency in the process of using AI. And my question, and it came to my mind like that the latest hype was blockchain, and blockchain is transparent by nature, and Graziela even mentioned the smart contracts. And I wanted to hear Ryan take on if blockchain is being considered in policy making as an alternative or as a way to actually have all the steps of a proper creation being tracked. And in this way we can see how it was used and avoid a little bit of the black box nature of LLMs that once again enter that, but and if there is beside the infrastructure's benefits of blockchain, but also this transparency that we were seeking.
Thank you, Gabriel. Anyone else? Please introduce yourself.
That one day there exists only data generated by artificial intelligence.
Thank you, Maria. Anybody else? Once? Twice? So the three last questions are from Anna. She wants a bit more about context in the federal government and AI in US and what could it impact abroad. Gabriel asks a bit more about transparency, talking to Graziela and William about the high blockchain contract policy making, what could that achieve? And Maria, our friend from Germany there, asked about originality and data. That's it.
Right. So what can I say about AI in the U.S. federal government and also blockchain, which is that the current government is very pro-AI and very pro-blockchain. Now, businesses are very widely using AI. I think kind of last year surveys showed businesses in the U.S. are like 85% using AI as opposed to 55% the year before. So people are using AI, but you know, AI has a lot of potential benefits. It has a lot of potential risks. You know, it is important that people are very thoughtful about what AI can do. You know, again, the self-driving car is a great use case, but you don't just kind of put it in the car and see what happens. I mean, you need a lot of governance and safety and thought. You know, this is a bit the EU versus the US style. I mean, this is the US style to its maximum. Like, we're just going to use AI in government right now, like, all we can and, like, see what happens. Not, I think, the approach I would recommend. I would be a lot more measured and thoughtful and governance-oriented to it. And so what's going to happen for other countries resulting in that? I think if it goes well, other countries will follow the example. And if it has a bunch of problems, which it will be a learning lesson to other countries that before you do this, you may want to think it through a little bit more carefully. Like, what do we want to use AI for exactly here, and how do we know that it's likely to have a good outcome, and how do we test it before we just start firing everybody and replacing them with robots? I don't think the AI is really quite there yet to do those things, but that might be part of the point. Blockchain is super interesting. People are talking about doing anything you can imagine with it. It is in my view, a solution in search of a problem. It has been very valuable as a store of value, right? You know, Bitcoin has done a great job with this. Lots of other cryptocurrencies have. I, still look for really good validated use cases of things that people have done with distributed ledger technology that work better than they wouldn't have without distributed ledger technology. Right? I mean, there's a lot of ways that maybe it could work, and I've been in the space for a long time, and I've heard a lot of exciting things, and I keep waiting for someone to actually do something tangibly useful. Right? Like you have smart contracts, which are automated contracts where you don't need human beings involved, where, I'm buying diamonds from you, and it's all happening on a blockchain, but then when you get into it, you're like, well, but someone needs to receive the diamonds and put the cash in, and how do we know the diamonds were delivered, and these weren't really diamonds, and then there's a dispute, and how do we take this to court, and wait a minute, you've done a deal with a miner, how do we get this off there? Like, a lot of challenges with this. So it is exciting to me that so many very smart people are working on this problem, and I'm optimistic they're going to find something useful for it, and in the meantime, I'm, waiting to see what they do. But if there's, another social example of someone just going full steam ahead on a technology, it's the current U.S. administration on blockchain. And so if there's something good that can be done with it, we're going to find out. The originality, right. How do we avoid the world becoming overwhelmed with AI-generated content? Well, I think AI is hopefully going to be the problem and the solution to the problem to this, right? Which is, well, you can have an AI generate an awful lot of stuff, right? But most of the stuff is pretty terrible or useless or garbage. On the other hand, there's also more content online that I could possibly consider in a lifetime, right? So I think there is going to be an important role for AI, not just in generating things, but also in validating things and kind of finding what is useful and, helping, us access an unlimited amount of information in a productive sort of way. And I think that is something that is going to need a technical solution, because there is just going to be an overwhelming amount of content that without the assistance of technology we're not going to be able to interface well with.
So, people are starving, and that makes people tired. Ryan, it was a great pleasure to have you here at the capital of IP in Brazil, which is Rio. It was always have been Rio, and if we can work, Felipe, Rio will be always the capital of IP and technology and AI of Brazil. Once we were the capital formally, but culturally we still are, and we'll fight on that. Thank you so much for everyone that's present. Now you can meet and greet our authority, Ryan, and I hope that the next time you're here, we can bring you back for more and more. Graziela, William, Felipe, this was our first joint task force work. I hope that we can work together more and we can produce the trust that Ana Tereza Basilio has deposited in each one of us. Thank you so much. Have a nice day.